there is a significant difference with respect to this issue that you just hit on between family court and Supreme Court because of the method in which the kind of decisions are made in each of the courts. Now, in family court, it's very, very common for the judges just to make verbal decisions based on oral applications of attorneys saying, hey, judge, I want this to happen. No motions, which is what motions are written requests of the judge to do something, which have to be responded to in writing, argued, and judge decides. So it's a boom, boom, boom process, a little more deliberative, right? In family court, you can expect things to change radically just based on lawyers asking for it.
Wow.
And judges make these decisions like that, life-changing decisions, really. It's incredible. So to the extent there's a risk, the risk occurs because of a failure of the application of the process.
Hi, I'm Rachel Green, Brooklyn-based divorce mediator and collaborative attorney, and this is my podcast, Keep the Kids in Mind. Join me as I chat with other industry professionals about everything from smoothly navigating your way through divorce to prenups, all the while keeping the kids in mind. Hi, everyone. Thank you so much for coming in to listen to another episode of Keep the Kids in Mind, a podcast where we explore how separation and divorce affects children and how you can choose processes and do things to try to protect them. I am very happy to have John Yacos as our guest. John is one of my favorite litigation attorneys in the matrimonial area. He's a lifelong New Yorker with over 30 years of legal experience. He was selected for the 2020 New York State Super Lawyers. He's also the director and co-founder of the Brooklyn chapter of the National Association of Divorce Professionals and serves on the board of directors of Family Kind, a nonprofit organization that provides supportive services on a sliding scale to families. John kickstarted his legal career litigating child abuse and neglect cases, and then represented children in contested custody litigation at the Children's Law Center in Kings County. So he's really seen a wide spectrum of ways that divorce can affect children. And fun fact, the first judge he appeared before was Judge Judy, who was a family court judge at the time. I didn't even realize that she had been a real judge.
Oh, yeah.
TV judge.
I'll tell you a little bit of the story there.
Yeah.
Today. Yeah. It's very interesting, actually.
Well, welcome, John.
Rachel, thank you very much for having me. I really appreciate it. And I have to say, Rachel and I actually attended the same law school together. Although we didn't know each other, we were there at the same time.
We did.
Yep. And then we got to know each other very well through the National Association of Divorce Professionals, as we were both members of the Brooklyn chapter. And I really, and Rachel is, I guess, the original mediator from what I would say Brownstone, Brooklyn community. And Rachel, I really, really appreciate this opportunity to talk with you today.
Yeah, I was the first full-time mediator in Brooklyn.
Yep.
I was that for about 5 years, and then Jessica Rothberg opened her practice. So then there were two of us.
But you were the OG.
Yeah. So, John, what are common issues that parents should consider during a divorce?
Right. So, and again, thank you very much for this. One of I think in terms of limiting the damage to children in the process is to keep them out of the process to the full extent possible, right? And as an attorney who worked at the Children's Law Center, I represented children. And I was in court all day, every day, pretty much on multiple cases. So I had a firsthand view of really what it was like for the children to experience, because I had the opportunity to talk with the children about what they were going through as their attorney. And I think from a psychological, emotional, ethical, and moral, and also legal standpoint, one of the points that people should think about if they're involved in any of this, mediation, litigation, is to make sure that you do not beat up or bash the other parent to the children, right? And the significance of that, I'll take it from the legal perspective. The significance of that is that people may be aware of the concept, this vague notion of the best interest of the children, right? and it's a floating concept. It really has no set definition in the law. It's purely based on case law, which are individuals' cases. And it's about 20 different factors that shift over time because the specifics of the cases shift. I would have to say the most significant factor that's really popped up in recent years is this. Does a parent actively promote the relationship between the child or children and the other parent? And that's not a passive thing. We just don't, I'm not going to talk about it. It's definitely not, talking negatively about the parent or doing things that are antithetical to promoting the relationship. It's actually, you actually have an affirmative duty to promote the relationship between the child or children and that other parent.
So you're saying a lot of things. So I just want to make sure I and our listeners are following. So I mean, the best interest of the children is kind of the standard in the courts for for making decisions about the children. Right. But as you say, it's kind of a squishy, subjective standard, really. But some of the things that are not squishy and subjective are promoting a relationship with the other parent. Is this parent who's before you accepting of the fact that I don't want this person, I don't want my ex in my life at all, but he or she is always going to be my children's other parent. And am I able to be supportive of it, like from the children's eyes, instead of just being tied up in my own feelings about my ex? Distinguishing those two things. And then there was one other thing you said that I wanted to catch on to, but it just flew out of my head. So I'll think of it.
Well, that's a key consideration. You really just want to make sure that everything you do is you're putting the children first, right? I mean, the two keys to this concept in terms of minimizing the harm to children is really one, above anything else, you put the children's consideration and needs above even your own with respect to the litigation. So I think that's really difficult for a lot of people to do.
It's challenging, but if you're striving for it and you're aware of it, at least.
Right. Because, you enter into this process, and we're talking about people who are either contemplating separation or separating or getting divorced, or however they're going to structure, their future. As you said, Rachel, most importantly, you're still going to have a relationship with that other person through the children, right? And that's really super significant, that the children see that you are, can work with the other parent, because children hate to be put, and this is, again, my professional experience interviewing all these hundreds of children, if not thousands. They hate to be put in the middle, right? Yeah. And when, parents are pulling at them, telling them all sorts of stuff during this process, it really, really is something that is very detrimental, psychologically detrimental. Yeah. It causes so much anxiety, manifest in all sorts of other psychological aspects like depression or just school.
Yeah. Now, John, you froze for me for a second.
Okay.
Now you're back. Yeah. Okay. That's the other thing that I wanted to mention that I heard you say is the best thing you can do for your children is to keep them out of it. Right. I was working with a couple a few months ago, and one thing that I know that one thing that psychologists recommend is that you not talk to the children until the parents have like kind of everything mapped out. Like, mama's going to move. She has this apartment. You're going to see her, Mondays and Tuesdays and every other weekend, whatever the arrangements are. Yep. You're going to have a bedroom in that apartment. We can walk over right now and see it, as much as you can have worked out before you even talk to the children. And I brought this up as an issue with a couple I was working with in mediation, and they said, they stopped me like mid-sentence, and they were like, our kids know way too much about our conflicts and our divorce. This train has already left the station. There's nothing to say. And I just got like a sick feeling, thinking about these poor kids, because this couple really is very high conflict. And, and I thought, oh my God, they're fighting like this in front of their kids. They just haven't been able to help themselves.
Right.
So those poor kids are going to just have, scars for many years.
Right. And one thing that I think parents don't credit their own children, frankly, is how smart kids are. Right. Even really young kids if they hear something, if they see something, they are internalizing it. They are taking it in, and it comes out, like I said, even young kids. And if you're discussing these issues, even in a civil tone, children will know it. If you're fighting, that's even worse. Right. I think, Rachel, your point is extremely well taken. And one thing that I didn't mention is that even though I'm, trained as a litigator, I'm extremely mediation friendly or alternative dispute resolution friendly, because I find how poor it is to go through a litigation process. Poor in the sense that you're leaving decisions up to a third party stranger. It costs a lot of money. It takes a lot of time. It doesn't necessarily increase the problems, but all of these other things create further issues with respect to, how much time and money, and the potential for bringing in the children, which I haven't discussed yet in terms of how children may be involved in litigation. That's why I think what you said, Rachel, is right on. I would highly recommend to anyone listening, attempt mediation first. Do not, and try to resolve all these issues and discuss all the issues that perhaps could be or need to be presented to children at some point, appropriate time, and plan on the method by which the children, with the mediator, with a couples counselor, psychologist, how children will be told about these things, because that impact is life-changing. If you think about, put yourself in the shoes of a little kid, and your parents are separating, the implications are life-altering, really.
Yeah.
So you really want to make sure that that's happening. Now, an interesting thing that happens also is that sometimes children, even young children, again, they will be curious and ask parents about issues that are going on that they see with respect to this, or even if it's kind of open that the parties are separating or separated, getting divorced, or whatever the situation is. The curious kids will start asking their parents questions. That I get that a lot from my clients. Mitigating the relationship between the kids in this process. I suggest to my clients, just tell the kids basically, this is an issue that it's an adult issue. Mommy and daddy are trying to work it out. Like sort of, don't really like tell them, well, Johnny, this is what's happening with us, and this is what I think, and this is what your mom or dad thinks.
Right. Don't give them that much information.
You got to take away, because I'm not a psychologist at all, but I know just based on what I've, my experience is that these kids are gonna at some level feel like they're responsible for what happened. Right? They're going to feel like,
yes.
I
always tell clients that. I say, you can never say it enough times. Every 2 or 3 months, you should say, by the way, you didn't do anything that caused us to separate. You didn't do anything, because children internalize. They think, if I only, picked up my dirty socks from the floor, mommy and daddy wouldn't have separated. They got so angry at me for keeping my playroom a mess or not doing my homework right away. And it's my fault. And I think they do. I think they do internalize it.
Right. And that was told to me directly by many children frequently, that concept where they felt they took on some personal responsibility for what was happening. And again, not a psychologist, but, I'd always have to tell them exactly what you were saying, that, it's not you. It's not you.
I had a couple once who said to me, they had their intimate life had ended, several years earlier.
Right.
So they felt like, well, we don't really have a real marriage. We're like roommates, and they didn't have active fighting. And they said, well, we feel it's important to separate because we think our kids, they on some level, they know that we're not having sex. And I was like, what? Like their kids were 6 and 8, like prepubescent.
Right.
I was like, you think your kids know? Like, I was going, you're dreaming. I mean, I've seen parents, like I've seen many situations where parents who are not actively fighting, like not screaming at each other and throwing things, if there's not active fighting in the world, children are very egocentric. They're tied up with their own things, their school, their friends, their homework, their and they feel like their parents are their parents. They're just there in the background. Yeah. And I was like, your kids don't, know, like that's the reason that you're separating because anyway.
Yeah. So also in terms of how it plays out in litigation, right? Again, I'm super big proponent of mediation specifically to deal with these issues. But if parties end up in litigation, there's a lot of different ways where it has an impact with the children. Now, some parents think that if they're assigned an attorney, as I was at one point, an attorney for children, that's going to be really a detrimental and traumatic event. I really didn't find. I think kids are a little bit more resilient than most parents think about this, and I tried my best to make it something that was a little smoother and easier for a kid to deal with. So it can't, depending upon a child's age, if you are litigating, it is very possible, and usually it's about 5 or 6 for most judges. Your child may be assigned an attorney to talk to them. In rare cases where there's disputes on custody and they cannot be resolved, there are times when children are actually brought into court and have a meeting with a judge. Right.
Would a child as young as 5 or 6 be asked to come have a meeting with judge, or is it only older?
Sometimes it's a pretty, I've had that. It's called an in camera, or for lawyers, a Lincoln hearing. And sometimes they do it with children as young as that. It's a little rare. The problem with, some of the litigation processes, you get judges who don't necessarily have background in, this area, in family law generally, because of the way the system works. So they're not really fine-tuned with respect to these subtle but significant issues concerning what's appropriate with this or not. So I've been assigned on cases when I was an attorney for children, for children who are infants, pre-verbal, and basically the judges at that point are looking for cover. Right? They want
they're
just judge in the room.
So they're just assigning an attorney for the child so that they feel like they made some kind of gesture toward having the child's voice or the child's best interest evaluated by somebody else.
Right. And I just as on this point, it's really I think it's interesting myself, but I call the phenomena the tail wagging the dog, because you have this little kid sometimes telling his attorney what they want. And if the child is old enough, as an attorney for children, you can either, do best interests, right, or straight advocacy, or you can substitute judgment, right? And if a child is old enough, you do what's called straight advocacy, meaning you're just a lawyer for a client and you push that, zealously with the court system.
But isn't the child going to feel terribly guilty if he or she says, this is what I want? Like, aren't they going to feel really guilty toward the other parent?
We're getting into like the area of how you advocate for a child, how you interview a child. So, part of the interview process is you never ask a child, you don't ask leading questions. You just sort of talk, and it comes out. Kids love to tell you stuff, right? I love talking to children. But they'll tell you things, but you never say, like, who do you want to live with, your mom or your dad?
Yeah, who do you like better?
But it comes out, and basically what you're trying to do is find out from a child, in terms of the interview process, you're trying to find out from a child what their life is like with each of the parents, who the parents are, what the parents' strengths and weaknesses are as parents, and kind of get a more comprehensive view of what's in the children's best interest, as opposed to something like that. And by the way, sometimes parents will always tell you, the other parent is talking to the kid and telling him to tell you stuff. But a lot of times, so sometimes when kids come in, they are actually told by the parents to say something to me, in that capacity. And you could see it. Their anxiety levels at the very beginning are tremendous. They're just sort of like filled with anxiety and this kind of nervous energy, and they just spill right off the bat. And you kind of know from that.
Right. I see. Like, it's like they've been rehearsing a speech and they have to like.
Exactly. And they just want to get it out,
Yeah. And get it done. Like, okay, I told my speech. Now I can relax.
Right. Exactly. And then the energy level and the anxiety subsides a little bit, and they become a little more relaxed, and you can just talk. And sometimes sometimes I would ask, did your mom or your daddy want to ask, have you tell me something, just to put it out there.
Right.
My mommy, these kids don't know. They'll tell you that, like they'll say that, that's what it is.
Yeah. So when you're the attorney for the child, do you have any conversations with the parents?
Yeah. As a matter of fact, the protocol for the agency that I worked with, which is Children's Law Center, was that you would meet with your client, obviously, the child, the children, and you would meet with both parents, and you'd meet with all the collaterals, right? So from that standpoint, your obligation as an attorney.
What do you mean by the collaterals?
Right. So, depending upon the facts of the case, you would want to talk to the school, talk to the pediatrician, talk to if there were therapists involved, if other family members were involved. Sometimes parents lived with other people and you want to talk to them, like the, new spouse, perhaps they might be remarried, things like that. So your obligation as an attorney for the child is really a mandate for comprehensive information. Like you, as any lawyer, you need to know everything. So, it was a quite interesting experience. Just to go on to further, potentially damage to a child, and I'm air quotes damage to a child in the litigation process. A common experience for people who are in, contested custody litigation is that there may be a forensic evaluation. A lot of people may not know that, and that's an assigned, usually psychologist, could be social worker, or could, in certain cases, psychiatrist, who does a written report. And it's a lengthy written report based on interviews, based on document review, based on psychological.
Yeah, I've heard they can be like between 50 and 100 pages.
Yeah, they can be. They could be, they have to be, fairly comprehensive. It's not, I guess you could say what you need to say in less than 30, but, really the amount of information that's provided in a forensic evaluation is tremendous. So they also meet children.
Those are done when the parents are really arguing about custody, about the children's schedules.
Yeah, you try to avoid it, and basically it's determined deep into the process where you think you're going to go to trial. So
I see.
There is case law.
That costs a lot of money too.
Oh my God, yeah. It's tremendously expensive. It takes a long time.
Could be like $75,000.
It could be, but it's interesting because if you talk to like Manhattan lawyers versus Brooklyn lawyers or other boroughs, you'll get different reads on how expensive, but definitely tens of thousands.
It's tens of thousands.
Yeah, definitely tens of thousands. And again, it's very intrusive. And in terms of the harm to the children, they are interviewed by the forensic evaluator. So oftentimes the forensic evaluator may visit the home or have them come in with the parent just to see the interaction with the parent at least. Right. So there is involvement with the children on that front too. So again, in the litigation process, you have one, the attorney for the child, potentially. Two, you have a remote, but still possible potential for the child to come in and discuss the issues with the court. Three, you have the potential for the child to be involved in the forensic process. So again, above anything else, in terms of everything I've said, in terms of mediation or alternative dispute resolution, this as part of litigation, the involvement of the child should be considered in terms of putting the children first, and also trying to resolve things before you say, screw this, we're just going to court. That's what parents sometimes say. They're just fed up with, trying to negotiate something, and again, keep children in their mental health more than anything else.
Well, I find the vast majority of people who choose mediation are choosing mediation for just that reason. And like I would say the majority of my families that I work with, not every family, but many of them do not really have parenting conflicts. Like they're like aligned in wanting to protect their children from the conflict arising out of the divorce. And they want to talk like out of earshot of the children in mediation
Right.
about, any decisions they have to make about the children. And they're really like, they come in with anxiety about how can we protect our children, which
Right.
is, for me, that's one of the most satisfying things,
Absolutely.
which is, I guess, why I called the podcast Keep Your Kids in Mind. I mean, it's one of the most like moving and satisfying parts of this work for me, when
Right.
I can help people do that, when we can talk about, okay, so this thing is coming up that's going to be a conflict. How can we shield our kids from our conflict?
Yeah, no, I agree with you 100%. I think one of the benefits of my practice, and my practice is 100% matrimonial and family law. So this is all I do, right? And one of the benefits of my specific form of my practice is I do a lot of work as a consulting attorney in mediation, right? So there, I get a good percentage of clients who are those types of people who are aligned with respect to how they view going through this process and the significance of how children might be impacted, and they want to protect and shield the children from it. And that is really satisfying that parents can do that. And then again, in terms of my practice, because I'm a litigator, I can continue, if mediation doesn't work for whatever reason, I can continue to represent them in litigation. And in those cases, oftentimes there is some more contentious disputes with respect to custody as one issue. One of the things that can be that we should talk about is the interconnectedness between child support and custody as an issue, and how that impacts children and the harm to children. And
Oh, yeah.
what I mean by that is that
you asked your own question, so
I
now
did.
answer
Thank you
it.
very
Right.
So
Such an easy guest to have.
yeah, thank you very much. So so it's relevant and important because an obligation for a parent to pay child support is premised on, at least for one aspect of child support, is premised on who is the primary residential custodial parent. So just as a background, so people hear it, there are two aspects of this is like 30 seconds on child support. Two aspects of child support. One is called basic child support, and that's what most people think. And that's based on who has primary residential custody. And there's a presumptive income calculation that's used to determine that. And that's for food, clothing, shelter, generally speaking. The other side of child support is this thing called add-on expenses, and that's pro rata. It doesn't relate to who has residential custody. It's just an obligation based straight on income. So if one parent is making 60,000, the other's making 40,000, the ratio for those add-on expenses are 60% to the 60,000 and
40%, right?
Right.
Mm-hmm. Yeah.
Right. And that's for childcare, medical, could be extracurricular, could be summer camp, things like that. Right. So what ends up happening in terms of the interconnectedness between child support and custody is that oftentimes custody is used as a surrogate to address the child support issues. Right. So sometimes you'll get parents fighting over custody and parenting time, and then causing more strife in the family and impacting the children because they're worried about an obligation on child support, right? So if they know, this often happens oftentimes with parents who are living together before they've separated, because before you separate, there really is no legal method by which, generally speaking, the court will allocate a residential or non-residential parent and therefore child support obligation. So oftentimes parents will stay together even though they know it's toxic and the relationship is damaging, the toxic relationship while they're together in this home is damaging the children. They won't separate because they don't want to establish who's the primary and who's not. Right. So as a result, they'll either stay together or they'll fight over custody. Right. And one thing people should know about this, if you're thinking about this, is that even if it's 50-50, like a lot of times parents, and consistent with the children's best interest, this might be true, that parties want to have what they call equal parenting time, right? They want to have literally 50-50 of the residential parenting time. What parties should know, just from a legal standpoint, is that if that is the case, the parent who makes more income is obligated to pay child support as if they are the weekend parent and only have Friday, Saturday.
Right.
So therefore, there's also that component too.
Yeah,
My
but I
point-
mean, in a negotiated settlement, we work that out in mediation. Usually, we
Right,
look at their expenses, their budgets, where they're going to be moving.
right.
And they take into account their incomes as well, and just say, how do you want to divide the expenses for the children? And we talk about different options, and they can come up with something that they feel is more fair. But
Great.
I'm hearing you say, and I guess my observation has been that if they ended up in court, then higher earning parent is just going to pay 100% child support regardless of the schedule.
Right. It depends on the discretion of the court. From an attorney standpoint, the case law holds, and I found more and more judges are just applying the case law, even though I don't think it's fair. The case law says that even if it's 50-50, the money spouse pays the full presumptive calculated amount, which is really unfair because you have your own, even if it's 50-50 as the money spouse, you have your expenses and you're paying all of the money in terms of basic child support to the other parent who's also 50-50. They do have expenses.
And then in New York City, rents are so high. I mean, the difference between getting a studio apartment, which probably a parent could get, versus getting a 2-bedroom, the rents are just like astronomical. So the higher earning spouse may have more expenses.
Right.
And it's really not a fair, it's not such
and this is a really, you really hit on a key point in terms of why mediation is so beneficial to parties, because in court, you're at the discretion of this judge who's either going to apply this, from my perspective, unfair aspect of the law, or what we call deviate and perhaps net out, or what Rachel said was really, let's look at the expenses. Let's be practical and smart about this. And let's look at what's fair. And you have so much more flexibility with the mediation process in terms of, crafting a resolution that makes sense than you do in litigation. Again, this is a key component with respect to minimizing the harm to the children, because this, again, the support issue is tied into the custody issue and vice versa. There's that interconnectedness. So you really want to use the resources of someone like Rachel, who is going to really be helping you structure this, because you could do it with lawyers, but it really takes a high level of cooperation in litigation with lawyers to do the same thing. And again, you want parents to be talking to each other, because they're going to have a life after we're gone out of their life. They're going to be together through the children for the rest of their life. So again,
and isn't it nice if they can go to the high school graduation, together, and the college graduation, and even weddings, and
even in high conflict situation, again, I feel like I'm beating the drum a little bit here, but the initial attempts to have those types of discussions directly with the assistance of a mediator is much easier than if you're talking through lawyers in a litigation process. So that's you have that buffer in litigation that you don't have, and it's more natural, really.
So John, one question I'm curious about is just like, how often do you have cases where you feel like, you go to court? I mean, I guess most cases don't really end up in court, do they? Or maybe parts of them are decided by the judge and then you settle the rest, but I'm wondering, like, how often you feel like, boy, that really was a bad result. Like, you just feel like the case. I mean, the thing, I find that people often have a fantasy that the judge is going to hear them and see everything they suffered through and say, oh my gosh, you are the wronged person. And the wise father that they never had is going to be this judge in court who's going to see them. And and my understanding is that the judges don't have the time to or the interest in getting to know your clients the way that you know them. But I'm just wondering, like, how often you feel like there really is like a miscarriage of justice in a certain way.
That's a really good question. Unfortunately, okay, so a couple different basic concepts. One of which is the court experience is not what people think it is. If people think it's going to be like this TV thing where the judge is going to be deciding everything, and it's really not that at all if it's done properly, right? And when I say properly, if the judge applies the law and what the limitations of what they're supposed to do. And it's extremely frustrating for parties because people, I've had cases, Rachel, where people have agreements, right? Literally written agreements. And they say, oh, I want to go to the judge and tell them my story because they have to hear this. And it's like, but wait a second, we're done. You have an agreement already, right? So you don't have to, I want the judge to know this. I want the judge to know this. Like, no, it's not going to happen. So they don't really understand. Part of my job is to really explore what the process is and explain every little detail because it's so confusing. I conceptualize it as a big black box that people enter into, and it's this thing that happens. I know it's in the black box, and I know how much I can tell them based on like what my experience is within a range of discretion of the court. And there's a tremendous amount of discretion. There's the law and the application of the law and the judge. So in terms of a miscarriage of justice, it happens, right? It is, it's deeply frustrating when certain cases end up just wrong. And the way it ends up wrong is that usually it's a decision by a judge that is completely inconsistent with the process of the law, right? So for instance, they're making these judgments on custody, parenting time, and or support, which are totally not supported by the process, because the process is supposed to be fair, due process, deliberative. You're supposed to have hearings for these things. And this, you're hitting on a really good point in terms of the concept of miscarriage or the concept of discretion and the options that parties have. It's really an important thing to understand is that even married people have the option to go to family court, right, for issues of child support or custody, which are heard by two different parties. Or if you're married and getting divorced, you can go to Supreme Court. Now, Supreme Court in New York is not the highest level court. It's another trial level, right? But it's where people get divorced, right? And as an unmarried person, you're going to probably go to family court, although COVID, there was some push that unmarried people could go to Supreme Court too, because family court was closed basically for a long time. So that was a new thing because of COVID. But there is a significant difference with respect to this issue that you just hit on between family court and Supreme Court because of the method in which the kind of decisions are made in each of the courts. Now, in family court, it's very, very common for the judges just to make verbal decisions based on oral applications of attorneys saying, hey, judge, I want this to happen. No motions, which is what motions are written requests of the judge to do something, which have to be responded to in writing, argued, and judge decides. So it's a boom, boom, boom process, a little more deliberative, right? In family court, you can expect things to change radically just based on lawyers asking for it.
Wow.
And judges make these decisions like that, life-changing decisions, really. It's incredible. So to the extent there's a risk, the risk occurs because of a failure of the application of the process. And the other piece of it is that, unfortunately, because of resources, sometimes you'll get more frequent turnover in family court of judges than you would in, say, Supreme Court, right? Supreme Court, they tend to stay a little longer. They have a little bit more experience, because they've been there for years and years. So family court, a little less so. They have great family court judges, really judges who are practitioners in this area who come and become family court judges. And again, you have others who are not, who are just sort of there, with no experience, and they're learning on the job, literally. And that's where the risk is in terms of the miscarriage of justice.
Are there any cases that have haunted you that just went wrong?
I'll tell you one. I'm really not going to identify who it is, but
no, of course not.
A case where it was a divorce. It was in Supreme Court, so it should have been. The expectation is it's going to be done properly in terms of the process, right? Now, it was a judge who didn't really have much experience either in the law as a background, right? This person didn't really know the law, this judge. This person was brand new, and this person, a lot of times when you get new judges, this is just an insight experience I'm telling you about, they put on a black robe and they feel like they're insecure themselves because they don't know what they're doing. Right. And they feel like I need respect. And therefore, the way I'm going to get respect is by ordering people to do stuff, as opposed to, thinking about it and being judicial and being, contemplative about what's going on and the impact of it. So it's really like they're kind of bullies almost in terms of like, hey, you're going to respect me because I got the black robe. right? So in this particular case, I was representing the husband. There was another attorney representing the wife. The parties had not separated, right? There was a motion before the court, but it wasn't fully briefed. By that, I mean, they had made the motion, but it was done as like an emergency. And when you
They
go,
didn't have time to really think about it and write a written argument.
Excuse me?
They didn't have time to really think about it and write up a written argument.
No, they did, because they take all the time they want. They write up like 20 pages of it, like an affidavit, which is a written statement. So they do that, and then they hit you and they call it an emergency, and you don't get the papers until you show up, basically. You don't know
I see.
And as a result, you show up. So nothing really should happen, except the threshold for granting emergency relief is very, very high. It should be something like abuse or neglect is going on, or extreme domestic violence, things that are really almost life-threatening, right?
Yeah.
In this case, they made that application. This was the first time on. Usually you're just addressing what the immediate relief is. This judge, in this case, decided to, because there are allegations that the parties were in strife, which is almost every case. Nothing, from my perspective, nothing unusual in terms of a divorce, because this judge really didn't have the experience. They read it, and they, again, I come from a background where I'm used to child abuse cases. I have had cases where children have died, where parents have died. There's been fatalities.
How horrible.
So, and that's true with a lot of attorneys and judges. So if you have enough experience, you've gone through this, where there's been a serious
Uh-huh.
issues of, this nature: violence, domestic violence, abuse, and so on. This judge didn't have that context. So this judge was reading these papers and seeing this stuff, and it's like, okay, the parties are together. I'm gonna kick out the father, the husband, my client, right now, just like that. Go find another place, and I'm gonna award maintenance, which is another word for alimony, and child support, without any real papers. Like what you have to do is provide financial statements. It's called the statement of net worth.
So were these just temporary orders, or were they they ended up being permanent orders?
Well, yeah, it's a good question, right? Temporary orders oftentimes become permanent orders, because they because okay, you make a quote temporary order, your next court date is 2 months later, right? And what happens then? It's sort of like, oh, that's in the past, and you're doing
and you've already been doing it for months and months, right?
So not without any information, the judge kicked out my client, awarded maintenance and child support at an extreme amount, which really kind of really damaged. I mean, can you imagine if you're the children and daddy's got to go, like daddy leaves all of a sudden?
Yeah.
For not a well thought out reason at all. Not a, just like not a reason that was really, contemplated, or, again, it would have been great if they had your services as a mediator to talk about this stuff, because ideally what the party should do is really through mediation, reach a written agreement with respect to the immediate issues that allow them to separate. So what those are, again, I'll tell you, when parents have children, you have to resolve in any divorce, whether it's agreement, which is agreements are 99% of the time, right? Or a judge deciding, you've got 5 issues, right? With children: custody, child support, maintenance, which is alimony, equitable distribution, which is the division of marital assets and liabilities, and the potential for counsel fees, right? So out of the five, you really have to decide, custody or parenting time to separate, and you need support. Could be maintenance and or child support. You don't need to do equitable distribution.
Property distribution or counsel.
I mean, you could do counsel fees, but to really, appropriately, so everyone's comfortable with the concept of separating, so the rights are going to be preserved to a certain degree, get an agreement that allows them to separate. It could be called a separation agreement, and it deals with parenting time, custody issues, and then you can do it. And that's the way to do it, not emergency motions to a judge, which is what happened with this outcome. What
happened with that family? I mean, did he just moved out and he had no choice because the judge ordered it?
I think I did a really good job. I got fired, of course, which was, it was expected, because it's like, and it was no fault of mine. We did a great job.
Well, you had no control over it.
Yeah. And then actually, I think he wanted to come back to me later. But, ultimately the case dragged on for about 2 years. More, because I had been in touch with him afterwards, and he kept, he was calling me. It was never undone. That was the end of it. I mean, they were going to separate, but the fact that it was like pulling a Band-Aid off a scab, a wound, as opposed to, like letting it heal and trying to resolve things. It was just so traumatic. It was really, and that's why it stayed with me so much in terms of your.
Well, I'm trying to ask you about your worst experiences, so.
Yeah. Right. So that was in terms of a miscarriage. I mean, my worst experiences, I can tell you lots and lots of more stories, but in terms of a miscarriage of justice.
Next time you can come back.
Right. But that was really, I think, something that stayed with me for a long time. And then there's a lot of other examples like that where it's just like, you have a range of one thing I tell my clients is that, there's like the experience, if you're in court, is on a spectrum, right? So, and I think it's like in the middle is the application of what the law sort of says, and the application is by discretion of the court in the middle, right? And it's sort of like a black hole. So everyone who's out on the outsides of the spectrum are being sucked into the middle, right? The whole process is, we're going to get you to what the law generally provides. So if you maintain a position that's outside at the end of the spectrums, you're going to have a hard time fighting the gravitation to pull you into the middle, right? So that, that is like what happens. So I try to articulate, I tell my clients that, and I tell them this is what's probably going to happen with a range of discretion, right? But then again, when you have these situations where a judge applies the law and it's just so aberrant, it's just like way off the charts, and it's like, how the hell did that happen? Like this is like, whoa, that's like crazy. The same thing. I mean, just as a short story, I had a case this week. It was in a court called Integrated Domestic Violence, and it's a court in all the counties where they try to group together a case that may have a criminal component, where usually domestic violence, where someone's been arrested. It might be a matrimonial, might be family court. So instead of like 3 or 4 judges, you get one judge, right? So in that case, even though it's a Supreme Court case, and it should have the law applies to family court and Supreme Court. So I'm making a distinction that is true, but there shouldn't be. But this is a Supreme Court case, and you would think that the application of the law would prevail, right? But again, it's one of the situations where you've got to just where the judge will entertain applications of custody, modifications of parenting time, like ad hoc, all these issues that usually are briefed in motion practice and papers. So you really have to like be careful, because like anything and everything could come up in the course of that court appearance, and a judge is making these snap decisions on monumental issues that are for children. Talk about the harm to children, life-changing decisions that are just being made. And Rachel, you're absolutely right that there are other things that are pulling the court. Administratively, they're overburdened in the terms of the number of cases. They don't have a lot of time to, really sit down, and a lot of times they haven't read the papers, and they'll say like, okay, tell me about this. So you got, I call it short attention span theater, right? It's like you've got to really like hammer your points and give them the headlines and then try to support it, because they're making really significant decisions really fast. And they are beholden to this thing called standards and goals. It means I've got to get the case through the system in a certain time frame. And as a judge, they're being evaluated
by how quickly they move things on.
Right. And whether it's in compliance with standards and goals. So they're, again, they try their best, and I give them a lot of credit. But it's a very difficult for a litigant, for parents, and the impact on children. It's a very difficult thing, in terms of having to go through this. I also think,
in a typical case, would you then like really try to tell the clients that like how many variables there are that are not in your control, and that you would try to help them to settle the case? I mean, in the majority of cases, is that what you would do?
Oh yeah, 100%. I mean, a big part of my job with clients is client management and setting client expectations.
Yeah. And then talking to the other lawyer, and hopefully they're reasonable and they can.
Yeah, it's a very good point, because that case I just described, I have enough experience, so I knew this was the possibility and probability, right? So I called up the lawyer the day before and said, hey, what's going on? You got any issues you want to talk about? Because otherwise they wouldn't tell you, and then you get sandbagged. You get on the record, and all of a sudden, hey, I got 5 issues. Blah, 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 blah.
Right.
You're trying to deal with this stuff, right? So I know that certain lawyers will try to sandbag you on the record, right? So what I did is I just called up this lawyer and said, what's up? Do you have any issues you want to talk about? And he was like, well, I guess I can tell you now, reluctantly, very sheepishly telling me is like, oh, here are the issues. So at least I had an opportunity to talk to my client, say, hey, the lawyer says your husband said this. What's your response? So I was all ready, so the whole point is, you got to be, as a lawyer, you got to be prepared. And with experience, you should really be able to understand like how things could go sideways, how it could really just go bad.
So what personally has drawn you to this crazy work of helping families who are in conflict and transition?
Right. So, we attended the same law school. So I think the push for our law school was to push people into corporate law, really. And I had no interest, I think. I'm saying I think that our school tried to push people.
Yeah, I think that's true. Right.
So for me, I had no interest at all. Like my motivating, and continues to be my motivating force, is to help people through a difficult process, right? I never really wanted to, work for corporate law or even work at the DA's office or anything like that. I really just wanted to help people and use my skills as an attorney to help people. And that's why I started out in the child abuse area. Just as an aside, just on a short Judge Judy note, the reason that she got the TV show was because 60 Minutes, there was an article in the newspaper about her, and 60 Minutes did a piece on her, and they actually focused on my team as lawyers and our interaction with her during that period of time. And then, some producer said, hey, she would be great on TV. And she's exactly, aside, she was exactly the way she is on TV.
Yeah.
Has been as a real judge. She used to put on the robe and say, this robe gives me special powers, So what motivated me was that, really. It was to help people. And even now, what I tell people is, I'm here to assist you through a difficult process, use my skill and expertise and experience to help you go from point A, which is where they are now, which could be anywhere, really. It could be, I'm just thinking about it, I'm already in it, where it's post-judgment, and, I need to modify or there's a violation, and get them through the process with the least amount of trauma, toxicity, expense, efficiency, and help them, and it's hard because it's a real burnout job, but I've been doing this for 30 years, and you always try, it's difficult because you try to empathize with them and keep that level of empathy that, this is really, even difficult clients, because, I have a lot of difficult clients, because I understand it. They're going through, they bring whatever
they're going through one of the hardest things in their lives. So they might be difficult, and then a couple of years later, they're transformed.
Yep. And I've gone through a divorce myself, and I know how difficult it is, but I tell my clients, keep trying, you can still find love, after a divorce and at the end, but it is extremely difficult. It's really hard. And that's kind of, Rachel, that's really my motivation at this point. And also, the other piece of it is I have a very strong sense of fairness. Like I think that comes from my parents. I think it comes from, the era in which I grew up, like the cynical 70s, with the Watergate, Vietnam War, all Nixon, all that stuff, where you didn't trust people, but you really want to have a sense of fairness in the process. And what motivates me most is when when you talked about the miscarriage of justice. And really, I work best for those people, who I feel like, wow, they're really getting screwed here. So
and you want to try to right the wrong.
Yeah, exactly. Right the wrong. And that's kind of, again, over the course of these many years, I've focused on that and really been able to hone in on that value as something that's really the dear to me and motivates me on even getting over like the how difficult this job really is. And it really is a very difficult job.
Yeah, it is. But it's always interesting.
Oh yeah, I mean it's extremely interesting. Yeah, that's the other piece of it. When you say like why do this? If you're interested in people, right?
Yeah.
I love I love hearing about how people have structured their lives. How you deal with your own reality. Not even just with the difficulties of going through this process, whether it be divorce, separation, but just like and I respect how people deal with their own existence, and
right.
and that kind of motivates me. It's like, wow, that's interesting.
It's kind of fascinating. I mean, I have to say, I feel like honored to be let into their lives and to hear to hear how they structured things and their hopes for the future, and trying to figure out what's the best way to get them to that, get them through this transition. And
right. And we both hear so much.
I know. Yeah. And it's just endlessly fascinating. I mean, I really find that like every family is different. It's kind of amazing.
Yeah, it is interesting that way, because they're all kind of permutations of similar issues, but when you get into it, it's so unique to these individuals, and everything that goes on, and the dynamic of relationships is just so fascinating to me.
Yeah, it's so fascinating.
It is.
And in mediation, I see both of them, so I kind of get like a fuller, picture. But sometimes I'm like amazed, like they're doing something that to me seems crazy, but they're like both doing, they're like, of course, this is how we're raising our kids. And I go, why are they getting divorced? Like, how are they ever going to find another person who matches them? Because they're both crazy in the same way,
We have an expression: elephants don't marry giraffes.
That's right. That's right.
So if you get down to
just two more questions. How many attorneys do you have now in your firm? Like, if somebody comes to the law firm of John Yacos, do they get John Yacos, or do they get?
No, they get me. They get me if they want me. I had someone ask me that same question just yesterday. My firm currently is 2 lawyers. It's me and my partner, Sherry Bornstein, who came from Family Kind. She's a mediator herself. She's a collaborative lawyer.
Right. I know Sherry from the collaborative.
Right. She's great. She's
great. Yeah.
Over 30 years experience.
Yeah.
Everything in our firm is transparent. So we all kind of share cases, but you can go to one of the attorneys. We had a third attorney. We're going to be hiring a third attorney because it's good to have a third attorney. And we have 2 legal assistants, one with a lot of experience, who's been with me for over 7 years, and another one who's relatively new but has an MBA. So she is someone who has got a lot of smarts and is really a great person and a great addition to the firm. And we're expanding, so.
Yeah, that's great.
Yeah, it's really great.
And then we're going to have your contact information on the show notes, but anything you want to say about how people can reach you?
Yeah, I think the best way to reach us is to call us, 212-587-9560. You could also email me, John, John, at yacoslaw, that's all one word, .com. So it's YAC as in Charlie, OS, Sam, LAW.com. So John at yacoslaw.com is a good way to reach me too.
And if you can't find him, just shoot me an email and I'll give you his contact information.
I'm easy to find. My name is fairly unique. So
yes.
So you can get.
Well, this has been a pleasure. We've covered so much information. And if anyone listeners have questions, you can shoot those to us as well. And it was really fun, John. And
Rachel, this is great. I really appreciate it.
I feel like we could have talked another hour, but
absolutely,
it's time to end.
100%.
So thanks a lot.
Okay, thank you.
And thanks to all those listening, watching, and remember, keep your kids in mind.
Absolutely. Thank you, Rachel.
Bye-bye.